to be here. Hello, everybody. So we have about 15 minutes and I just cover some recent developments, but also then to focus on a more specific topic, which I want to talk about, which is regulatory developments. Generally, there isn't a whole lot that is new, particularly since we had our meeting back in May and we talked about some of the developments. The most significant issue probably is the Maryland paid leave law that was passed, but that's not going to go into effect for a couple of years, and we're looking at regulations probably sometime next year. So there's not much to say about that. Where we are seeing some movement and change is in the regulatory front. And there's a few issues I'd like to sort of run through on those, just so people are up to date on them, or at least aware of them and know to look at them. So often when we look at employment issues, we don't think beyond kind of what the legislature has passed, what the EEO regulations might say, and think more, what are these agencies actually doing? First up on our front is OSHA, which, as you know, tried and spectacularly failed before the Supreme Court to pass a vaccination mandate for all employers, which the Supreme Court found was not justified based upon the congressional delegation of authority to that agency for rulemaking purposes. Now, at the same time that standard, the OSHA standard, was issued or overruled by the court, they also upheld the CMS standard that applied to healthcare facilities, finding that contrary to what was in the OSHA statute and the authorization provided there, the Medicare statute plainly provided authorization to the Secretary of Health and Human Services to promulgate regulations. Now, the whole issue of the regulatory scheme, to some extent, is going to come into question as we move forward, and I'll talk about this a little bit later on with the West Virginia versus EPA case that was decided, where the court created a new standard in determining the extent to which the legislature has ceded authority to an agency to promulgate regulations. And that's going to be an important question sort of flowing through all of what we discuss, because regulatory authority is what defines most of the rules you all live by, be it health and safety standards promulgated by OSHA, be it regulations pertaining to Fair Labor Standards Act, be it regulations pertaining to Medicare, Medicaid compliance, or be it standards pertaining to discrimination in the workplace, although there's less rulemaking there than there are in other places. So one can expect that there'll be challenges coming down the pike to anything that is promulgated through a rulemaking process. On the OSHA front, OSHA is actively working on a permanent rule on coronavirus healthcare standard. They had some public forums over the last several months. Those have concluded, and one can expect that sometime probably within the next 6 to 12 months, we might see a standard be proposed as part of the rulemaking process. There is a national emphasis program out there for COVID for healthcare organizations, and they are conducting inspections. However, those inspections are focused on employers who have been previously cited and have not shown through subsequent inspections to have taken corrective actions. And if you are unfamiliar with those standards, I would encourage you to take a look at those. They're lengthy, they're full of OSHA speak, and they're also confusing to some extent as to what the scope of the expectation is. But like I said, I can expect a final standard coming out for review and comment, and then implementation, and then probably immediate challenge from some organization saying it exceeds rulemaking authority, but we shall see. In the Department of Labor, they have announced that they are actively in the process of creating a final standard as it applies to independent contractor relationships. And this has been kind of a bugaboo of various administrations over the last several years. There was a standard that was a rather strict standard implemented under the Obama administration, blocked by the courts, done away with by the Trump administration, and now the Biden administration is focused on creating a new standard that would be within the scope of what the DOL would say is a basis for determining who is and who isn't an independent contractor. And in your facilities, the most likely source of these issues is going to be home care providers, people who are hired perhaps by the individual residents, but are perhaps working for an affiliated organization to your CCRC, or are even acting as independent contractors, but compensated through a payment scheme that's run by an affiliated organization. So these are not something to ignore, because independent contractor challenges can be quite expensive in the FLSA context, because they raise questions about wage compliance and overtime issues. And then, so that's really what the DOL is working on. They've stepped up enforcement to some extent, particularly as to misclassification issues. Now what I'm going to switch to is the EEOC, which doesn't really issue rulemaking so much as they issue guidance. And if you haven't visited the EEOC's webpage in some time, I would encourage you to go and look at their guidance. Anyone who's heard me or my colleague David Stevens speak at any leading age presentation will know for certain that there is lengthy guidance on the ADA, coronavirus, religious exemptions, et cetera. You should all have access to that, and you all should have read it in some detail. It hasn't been updated since March of this past year, so anything we said was that the conference was relatively current. What they have issued since that time, and this may or may not apply to you to some extent, but I'm going to go through it because I think it has some relevant points which you all should consider, particularly in this day and age, as the manner in which hiring and employee evaluation changes. The EEOC is trying to keep up with it. Now, having read these Q&As and their guidance, I'm not entirely sure that they have a lot new to say, and some of their analysis begs a lot of questions. But what they did issue recently is, and I'll use the title because I think it's entertaining, ADA and the use of software, algorithms, and artificial intelligence to assess job applicants and employees. Now, what they're really getting at is basically software programs that will be utilized by employers to screen out large numbers of applicants, to make evaluations and assessments based on those applicants' performance in online tests, or to otherwise evaluate those applicants based on an interview that's done online or in response to a chat box or visually, where, for example, an algorithm might evaluate somebody's response time to a question, the manner in which they respond to a question, analyzing speech patterns, et cetera, which might be then used by that algorithm to screen out particular applicants. And this has been a little bit of a bugaboo for the EEOC because they take the position that any type of program or application which doesn't provide a reasonable accommodation to a disabled individual, to put them on the same footing as a non-disabled individual, is potentially discriminatory. Okay, so when they're talking about an algorithm, what they're talking about is essentially a set of rules that the computer uses to make a decision. And artificial intelligence takes that a step further and uses the decision-making process to rate and evaluate and provide guidance and information on things such as speech pattern and test performance. Now, a lot of these programs might use chat boxes, or they might use speech pattern recognition systems, or they might make analyses based on a person's resume to make a decision about that particular individual and whether or not there is a basis to exclude that person given how they respond to certain tests. So for example, let's give an example that they might use. Has to say was an individual may need a reasonable accommodation and take a particular test. And if an accommodation isn't given at the outset, it may make their testing inaccurate. And then therefore there may be a requirement for a more accurate testing format. Most of you would accommodate this upfront by asking if there's any need for an accommodation in the individual taking any type of online test or assessment, and address that up front. There may be other issues where the response time to a chat box or to questions is evaluated as a basis for determining that person's suitability for employment. And the individual's disability may prevent that. So an employer needs to be aware that if that's an assessment tool being utilized by their screening software, if they have it, then they need to make an accommodation for that in order to ensure that those issues aren't being used to screen out an applicant who might be otherwise qualified. There are other issues as well that come up. And one of those is, it says a chat box might be programmed with a simple algorithm that rejects all applicants who during the course of their conversation with the chat box indicate they have a significant gap in their employment history. If a particular applicant had a gap, and if the gap was caused by a disability, then the chat box may be functioning to screen out that person because of the disability. Now, I find that an interesting analysis, because in a lot of cases, employers just looking at resumes will screen out persons based on the resume if there is shown to be a significant gap of employment. And in rare circumstances, the person might be qualified, they might interview them to determine why that gap exists. Now, that question should in any case be answered or asked when there is a gap in employment. And if your algorithmic program isn't set to identify that and ask that question, then it's problematic. So they give a series of guidance questions in their Q&A that they've issued about what you can ask of those particular employers or those particular providers who are offering these types of software to assist you in making assessments of applicants, to ensure that those tools are not screening out applicants who might otherwise be qualified but for a disability. And I would encourage you to take a look at it. I don't have time today to go through them in great detail, but this guidance is an outflow of what has been over the last couple of years, the EEOC's growing interest in employers using online tools to recruit, assess, and reject or hire applicants. A couple of years ago, their big issue had to do with employers who were recruiting exclusively online and in things in which younger workers would focus, such as Facebook or Instagram or other tools. that might appeal to a younger audience and not an older audience. And they were looking at these as potentially discriminatory in the age context. And in fact, they did go after some larger Silicon Valley firms for utilizing these types of tools for their recruitment. So the takeaway from all of this, and I think to a certain extent, I think their guidance is stretching the impact of these tools, particularly in and among smaller employers. But to be mindful of the fact that that software you have is a tool. It is what it is, and you should be aware that if that tool acts to screen out persons in a way that you would screen out persons in your own day-to-day HR function, then it's probably problematic. And you can't rely on any promises made by the provider of that tool. You have to either question them in detail about what functionalities have been implemented in order to assure it's not screening out persons who are disabled. And as they say, this applies, although it's written in the context of the ADA, it could apply in every other situation, not screening out persons who are too old or are older, and therefore an age discrimination violation. So I think I've run over my allotted time, but I just wanted to go over that, give you sort of an idea as what some of the focus is in the primary agencies that you're going to run up against. I hope that was helpful to all of you.